All right, I think we are ready to get started. I see that Mayor Hart has joined us. Mayor, uh, the floor is yours whenever you're ready.
All right, thank you. Thank you, and welcome, and thank you for participating in this Fair Chance Initiative training webinar. Of course, as you know, I'm Waterloo Mayor Quentin Hart. Um, but on a personal level, I'm proud that the city of Waterloo has taken this bold action and is the leader in the state and state of Iowa, and frankly, in the nation for cities our size in passing a fair chance ordinance. I am aware that not everyone agrees with the ordinance, and many may have doubts and questions. But it is our hope that these will be resolved through this training and the other resources that we are making available. I also believe that the work will speak for itself, that the outcomes will prove that we have made the right decision. The ordinance was passed to remove barriers to employment, reduce recidivism, and give a second chance to deserving Iowans. It's simply a good business practice that will help meet our ever increasing workforce needs. And first and foremost, I believe it's the right thing to do. And I wish to thank all of you that have led the charge to pass this Fair Chance Initiative, particularly Abraham Funches of the Waterloo Human Rights Commission, Councilperson Sharon Juwan, and the passion of Councilman Pat Morrissey. But I also want to thank all of you that served on the Education Committee to create this training. Carrie Dara of Cedar Valley, Gross Cedar Valley, Lance Dunn, the City of Waterloo Human Resources Director, Kingsley Botchway with Waterloo Community Schools, Brooke Kraft of VGM, and Meg Cernit of PDCM Insurance. And a special thanks goes to Kyle Roed of CPM and Lauren Peterman of PDCM Insurance, who did much of the heavy lifting and are key presenters today. But I assure you that the time you are investing will reap huge rewards for generations to come for your company, our community, and for the many people deserving of a second chance. Thank you.
Thank you, Mayor. Well said. We will go ahead and get into the presentation here. A few housekeeping items for today's webinar. Do note that the session is being recorded. The recording link will be shared via the city website as well as through the city's YouTube channel. All participants are muted. We are going to be taking questions during the session. If you are not familiar with Zoom, there is a Q&A button within the application that you can click in and you can type your question. We will be compiling those questions and we will answer them at the end. You'll put the question simply in the compose box and select send, and then that will come to myself, and I'll be reading those at the end here. Of course, if you have additional questions after the webinar or you are watching the recording and cannot join us live, feel free to visit the City of Waterloo website to submit your question for additional resources as well as a copy of the ordinance. First, most important thing that I want to start off with is a legal disclaimer. So I am not a lawyer, and Lauren is not a lawyer. So no information in this presentation is intended to provide or suggest legal advice. If you have specific questions, you should seek legal advice from your in-house counsel or another third-party legal counsel who is well-versed in employment law and understands the implications of the ordinance. So I want to start off just by talking a little bit about the reasons why and a little bit about myself. So if for those of you that aren't familiar with me, I'm a human resources director, and I work in a company in Waterloo called CPM. We're a manufacturer, but I've been working in human resources for within the Waterloo Cedar Falls area for a little over a decade, and I've hired a few hundred people in that time, and so I'm relatively familiar with some of the hiring processes. And I'm also familiar with companies who have taken voluntary steps to do fair chance hiring initiatives, as well as companies that have not. And so hopefully I can share that perspective with some of you. The first thing I want to talk about is really the reason why. And, the goal of this webinar is not really to debate the merits of the ordinance. It's really to provide some information and content for you who are operating within the city of Waterloo. So the primary reason focus was to remove a barrier to employment for individuals. So really, the goal was to give second chances to deserving individuals. The primary goal of a Fair Chance Hiring initiative is to judge applications on their qualifications, and that really is knowledge, skills, and abilities of an individual. When there are questions and processes within an application and within a hiring process that don't focus on qualifications, then implicit bias can occur within the selection process. So that's the primary goal. We want to reduce recidivism. We want to return people into our society. It's good for the community, and we want to make sure that they have gainful employment so that they don't make a mistake and end up incarcerated. So that's one of the primary goals as well. It's also just a good business practice and driven by the workforce need, and the term that's commonly thrown around is the war for talent. With low unemployment, coronavirus notwithstanding, there's really a high competition for talent, and quite frankly, there's a lot of talented individuals that have say some criminal convictions on their background. So before we get too much farther into the presentation, I do want to share with you a video that just goes into a little bit into one of these individuals' stories.
I'm originally from Ottumwa, Iowa. I was born here, and the marriage between my mom and dad was pretty rough. My dad was pretty abusive towards all of us. My mom and dad ended up splitting up, got a divorce. Growing up, I kind of felt like I wasn't good enough, I guess. I started drinking pretty early, and then when I was in high school, got to smoking marijuana and led to meth. I was fighting mixed martial arts. I really enjoyed the competition, and plus, back then I wanted the image of a badass, and what better way to do it. Ended up leading to steroids later, and steroids is pretty much what helped my life fall apart. It turned me into an animal. It took me 5 years of being in prison and still had 5 more to do. That's when, everything just changed.
We look at this as a training program that changes lives. That, there's something in Steve I could see that I just knew that he could turn around and he could be such a good, productive person because he had that polite side to him. We worked and got him into this apprenticeship program and kind of forced him into it. Once he was in it, Steve was all in.
When you finally give up and you're like, okay, this has got to change, and the guy upstairs and me is the only two that can do it. So I was finally free,
This program's about training individuals of what they want to do in their lifetime. Because if they're doing something they like to do, they're going to be successful doing it.
And he said, when you can weld 2 cans together, come talk to me. And I went and I rounded up 2 pop cans, and
everybody knows how thin those are. And he TIG welded those 2 aluminum pop cans together for me without a hole. Highly talented individual.
It was pretty neat to see the excitement in his face.
One of the prize treasures and trophies I have today sit in my office of 2 aluminum pop cans. He finished his program and became a journeyman in his field.
I transferred to Newton, so Tim contacted Brett Reyes that worked for Iowa Workforce Development in Newton Corrections.
He took advantage of every single service that I could possibly offer. Mock interviews, helped him with the resume, filling out applications. We set up a phone interview. He was able to talk to his boss now. I think they were really impressed with him completing his welding apprenticeship. These programs are 4 to 5 years long, and if you're not passionate about it, you're really not going to complete it, let alone do it for the rest of your life. He got a job 3 weeks before he got out, and that's huge.
He was so thankful that we were giving him a chance. It makes a big difference when you go in for a job interview, how you present yourself. And he's just one of those special people that has that great personality. He said that it was just like he was home, that they welcomed him with open arms. Makes you feel good in your heart that your team is doing that.
He's a perfect example of what an offender can do while incarcerated to be successful. I talked with his people that he works with, and he'll hold the door open for them and thank them every day. That makes me very proud, kind of like a proud father.
Winter gave me an opportunity, and I don't ever want to jeopardize that opportunity. Very grateful.
I would encourage the employer to really look in, what did the offender do while they were incarcerated? What did they do to become successful? Look at those people. They already have made their mind up. While incarcerated, they wanted to change.
There's a lot of talent in prison. There are people in there that want to get out and do right. They'll start at the bottom and work their way up.
Having an employer give somebody a second chance and never thought they were ever going to be able to get one ever again, they are grateful.
I just think everyone can change.
I mean, it's an amazing thing, because when you're in there, you think it's the end, and it's a new beginning.
All right. Powerful story. Steve is an exceptional individual and certainly deserving of a second chance. So that's really at the heart of this ordinance. So a little bit about the movement on a national level, and then we'll focus on the community level. But there are a few organizations that are championing fair chance initiatives. So the National Employment Law Project, which is a group of employment lawyers, the Equal Employment Opportunity Commission, which I'm sure many of you are familiar with, and then numerous civil liberty and workers' rights groups have really championed this movement. Some of the private employers who have joined: Walmart back in 2010, Target in 2013, Bed Bath and Beyond, Koch Industries, Home Depot, Big Lots, Marshalls. It's really some of those larger employers have joined the movement voluntarily, and I would say primarily because they have identified that with the lack of available talent, that they need to adjust and modify their employment practices to expand their talent pool. A little bit about a history of fair chance initiative laws. So as of today's date, 35 states have adopted statewide fair chance initiative laws. Hawaii was the first state back in 1998. And then you can see from the chart there that major cities in 2005, 2007, Boston, Austin, Oakland, and then some other major cities in 2008 to 2011. And we are continuing to see a trend of this. 2015 to present, we're really starting to see some momentum related to private employers who have done this and actually seen a lot of success with it. And now that trend is starting to catch on as well. 13 states and 18 cities in total, and counties have extended these laws to private employers. And in this case, the ordinance in Waterloo does extend to private employers as well. Some local statistics and background. So the ordinance was championed by the Waterloo Commission on Human Rights. This training actually was derived from a local committee to develop some resources for our local organizations who want to be compliant with this ordinance and want to make sure that they do the right thing as it relates to the Fair Chance hiring ordinance. So the City of Waterloo, Grosse Cedar Valley, Unity Point, Waterloo School, CPM, VGM, and PDCM Insurance all had representatives come together to build out this training and to ensure that we had the appropriate information to educate our local organizations on compliance. In December 2019, some local statistics on unemployment rate: 3.1% unemployment. That number is higher now, obviously because of the COVID-19 pandemic, but there are still a number of employers who are looking for talent. And I think the other, maybe the more critical statistic that I really focus on is something called participation rate. And participation rate is defined as the the percentage of the population above the age of 16 that is actually working and participating in the economy. And if you look at the statewide statistics, Waterloo Cedar Falls is actually one of the lowest participation rates as compared to the other metro areas in the state of Iowa. And if you really start to peel back some of that data, what you begin to identify is that there are a number of individuals who are motivated and wanting to find work, but are being missed because of some sort of a barrier that's in their way. Through numerous statistics and surveys over the last few years, the number one barrier to business growth in Cedar Valley is hiring employees. As I'm assuming many of you on this call are in a hiring employee position, I think you would all probably agree with that. Some of the local employers who have joined the movement, Waterloo Schools, CPM Roskamp, my organization, we actually banned the box voluntarily about 5 years ago on the advice of legal counsel. A story that I like to tell about that is the fact that we've hired numerous people with criminal convictions, and we've had no security issues because of that. You know, I know one of the employer fears is something related to vicarious liability or negligent hiring. Again, we've had no issues at my organization, and I would just say that, you know, one of the stories that stands out for me personally is the fact that we had an outstanding individual come to us through a temporary staffing agency. He started as a contingent worker. The temp agency didn't even want to send him. They basically said, "Yeah, this background's, it's too bad. We're not going to send him out. It's just it's tough." Well, my manufacturing manager at the time is a believer of second chances, and quite frankly just needed the help. So said, "You know what? We'll give him a shot. Send him out." That individual came out and had been looking for a job for years, and had been bouncing around from jobs that he was extremely overskilled for, and just hadn't found a home. So he was appreciative of the opportunity. He took that opportunity to demonstrate exemplary work ethic and work performance, ascended very quickly. We rolled him over to permanent in early, and paid a conversion fee to get him hired early. At this point right now, he is in a supervisory position overseeing 6 individuals, and I wish I had 10 more on my team just like him. And so, you know, the value of second chances, and I think that the human element of giving somebody an opportunity to prove you right that they have talent can go a long way. Some of the other private employers, VGM and PDCM Insurance, have also joined the movement along with Birch Manufacturing in Waterloo. The ordinance itself affects Waterloo employers with 4 to 14 employees, but the only real requirement for employers of that size is what's commonly referred to as banning the box. So that means no question asking about criminal convictions on an employment application. So that is, if you're that size of an organization, that is the consideration that you need to take a look at. Relatively simple requirement: get out the whiteout and take it off the application. The other note that I will say is some employers are exempt per the ordinance, and they are specifically called out in the ordinance. So if you feel that you may be exempt, please review the ordinance, review that as appropriate with legal counsel to determine that you may or may not need to follow the ordinance requirements. For Waterloo employers with 15 or more employees, there are a few more requirements that we have to adhere to. So the ban the box requirement is included, no question asking about criminal convictions on an employment application, but it goes a little bit deeper than that. So there are no questions allowed during an interview pertaining to a criminal background. So if you have a standard interview question and the question specifically relates to tell me about a conviction and tell me about the scenario and tell me about the situation, during the hiring process, you cannot ask that, at least not before a conditional job offer is extended. No background check until after a conditional job offer is extended. You can still do background checks, but you have to follow the appropriate cadence of the hiring method. And I would argue that that is actually a best practice prior to this ordinance being in place. I always recommend no background checks until after a conditional job offer is extended for a myriad of legal reasons. And the other comment for employers with 15 or more employees is that adverse hiring decisions cannot be made without a legitimate business reason. And that's really where I'm not an attorney, so I won't pretend to give legal advice. But a scenario that may make sense in that category would be hiring somebody for a tax. Let's say they're going to be a tax consultant helping somebody file taxes. If they have a conviction for tax fraud, that is most likely going to be a legitimate business reason. But it does need to be legitimate per the ordinance. There are practices that are allowed under the ordinance, and there's some common misconceptions. So let's talk about what you can do and what this might look like through the hiring process. So a candidate can voluntarily disclose a criminal background during the interview process prior to a conditional offer. That is their information to share. If they choose to voluntarily share the information, they can absolutely do so. In my opinion, if an individual who has a criminal conviction comes out with it right away in the interview, I have actually just screened them for trust and transparency, and I sincerely appreciate that candor from a candidate. However, per the ordinance, if they share their criminal background prior to the conditional offer of employment, an employer should disregard that and continue with the usual hiring process. The reason for this is that after a conditional job offer, when you've gone through an actual background check process, a lot of times criminal backgrounds have been expunged. There are potential differences in what a candidate has shared with you versus what the actual criminal background says. You should not just stop the process and assume that you can just go off of that information. The ordinance does specifically call that out as a requirement. Again, you can run a background check after a conditional job offer. Lauren is going to run through the phasing of that and the steps that you'll need to follow. And a conditional job offer can be rescinded with a legitimate business reason. The example that I used earlier, somebody convicted of tax fraud seeking a job as a financial accountant. That is not an extreme leap of logic to think that may not be a great business decision to hire that individual. Federal and state laws are also still applicable. And so one of the things that I think is really critical to understand is that this is a local Waterloo ordinance, but there are a number of regulatory requirements related to the use of criminal background and selection of candidates from state and federal law. So to go through that guidance, I'm going to turn it over to Lauren to take you through the rest of this presentation.
Thank you so much, Kyle. So good morning. My name is Lauren Peterman. I am the HR specialist at PDCM Insurance, and I work in our human resources consulting division, which is called HR Connect. And I assist our clients with a variety of HR challenges. One of the areas I tend to specialize in is employee handbook creation. Kyle didn't mention this, but he is the Workforce Readiness Chair on our Cedar Valley SHRM board, and I'm also the secretary on the board, so we serve together as well. And I'm very excited to be here with you all today. So I have to start off by saying I'm a bit of an HR nerd, so some of this could get a little dry, but it's super interesting to me. So if you have any questions, feel free to chat them in, and I'm happy to review those. So I'm going to start off by talking about some of the federal laws that impact background checks and that have truly helped shape the city's ordinance. Ban the Box and the Fair Chance Initiative are not new concepts, and they are in line with best practices that already exist today. So the first that I'll talk about is Equal Employment Opportunity, or EEO. And this states that employers must comply with federal laws that protect applicants and employees from discrimination. And so the protected classes from this list include race, national origin, color, sex, religion, disability, genetic information, including family medical history, or age 40 and older. And so these protections are extended to all phases of employment, which includes the hiring process and makes it relevant to our discussion today. The next is guidance from the sorry, Kyle, do you want to switch back? Wasn't done yet, too excited. The next is Equal Employment Opportunity Commission's 2012 guidance, which is entitled Consideration of Arrested Conviction Records in Employment Decisions under Title VII of the Civil Rights Act of 1964. Super long title, but what this guidance says is that there are two ways in which an employer's use of criminal record information could be considered discriminatory and could open the company up to potential liability. The first is disparate treatment, and the second is disparate impact treatment. So those sound pretty familiar. So I wanted, or similar, excuse me. So I wanted to break them down. Disparate treatment is when you are intentionally treating two people differently because of a protected characteristic. This type of discrimination can be very obvious. An example of this is if an employer had a policy that it would only hire men and it would not hire women. Obviously, that would be pretty discriminatory. The second type of discriminatory action is disparate impact treatment. This can be harder to detect, and in a very general sense, it's the unintended consequence of the result of an employment action. So, for example, if a company's policies don't explicitly say we won't hire women, but all of their policies lead to not hiring women, it could still be considered discriminatory. So this guidance is really important in how background check results are handled and applied. Okay, and the last federal law on this list is the Fair Credit Reporting Act, and this gives guidance on what requirements are in place both prior to and after running a background check. So I'm going to spend the next few slides talking about that in more detail. Ready to roll now? Thank you. Okay, so prior to running a background check, the FCRA states that employers must provide applicants with a written notice that background check information may be used in employment-related decisions. And so this notice has to be separate from the employment application. They cannot be on the same form. Next, employers must get the applicant's written authorization to run a background check. This authorization can be on that notice I just mentioned, but again, both of them have to be separate from the employment application. And then if the employer is using a background check vendor, the employer must certify to that background check company that they've complied with all the FCRA requirements. Okay, after the background check is run, if you decide to hire the applicant, there are no further steps that need to be taken under the FCRA, and you can just continue on with your normal onboarding process as usual. However, if you decide not to hire the applicant based on a legitimate business reason under the ordinance, the applicant will first have a right to appeal. So the employer must provide the pre-adverse action notice prior to making the final decision not to hire. There's a few documents that must be sent. They include a notice of the background check report that was relied on, and a copy of a summary of your rights under the Fair Credit Reporting Act. I generally recommend sending these items to the address on file for the applicant via certified mail. So you can ensure that the applicant receives it. Sometimes it's easy to say, oh, I don't have that email or I don't have that cell phone anymore. So sending it via certified mail is the easiest way to do that. When I work with clients, sometimes they say, oh man, this appeal process is just too much. It's overkill. I don't know why we have to do it. And so as we were creating this presentation, Kyle shared a really good story about why it's so important. So Kyle, do you want to share that story?
Thanks, Lauren. And I appreciate you covering all the compliance stuff because you got the bad slides. It's really dry stuff. So appreciate everybody who's hanging out in there with us. But the first thing I would say is there's so many steps that are required for the FCRA that my approach is to just leverage a third party to help me manage the background check process, because otherwise if you miss one step, you're potentially running the risk of being in hot water. So I generally recommend that, and that's been my approach in the past. The adverse action, when I first started in my career as HR, I spent a lot of time in recruiting, and I just felt like, geez, this is this is just a really an administrative burden and a challenge until I had a situation that was relatively eye-opening. So I had a candidate at a previous employer who came back with a background check that was shocking to say the least, and it was a prostitution charge in Texas, and was an individual that I was just absolutely shocked to see that, and relatively recent charge. So we went through the process. We were utilizing a third party at the time, and we sent them the adverse action notice. The candidate um, called me crying and upset and absolutely shocked that this was on the record. She had never even been to Texas. Upon the investigation of the charge, it was discovered that there was actually an identity theft issue, and somebody had taken her social security number and posed as her as they were being arrested, and it actually was a benefit to the candidate. We helped her, identify the issue. She got it cleaned up, thank goodness. She had an absolutely impeccable and clean record, but that highlights the reason why it's really critical to make sure that you communicate appropriately and give them an opportunity to respond to some of those charges. We did get a few Q&As as well on some of the comments that I made related to individuals sharing their conviction information during an interview process and utilizing that in the selection decision. My other comment there would be that a lot of times a background check record does not align with exactly what somebody told you. And I would argue that you want to know either way and continue to run your process forward so that you can make sure that you're getting the most accurate information from court records that are legally validated to make sure that you are checking the box and not potentially running afoul of negligent hiring practices or any sort of adverse action. Thanks, Lauren. Back to you.
Thank you for sharing that. When I heard it, I was like, well, that's a really rare situation, but it definitely highlights the importance, because I'm sure there are a myriad of other situations where not quite as crazy and unbelievable, but still helpful to have the appeal process available. So thanks again for sharing. Okay, back to a little bit more of the compliance, and then we'll wrap it up and move on to some other things. So once the applicant has received that pre-adverse action notice, the applicant should be given a reasonable amount of time to review and respond. Like a lot of laws, the FCRA does not state what a reasonable amount of time is. So a best practice we see is to give 5 business days. So if the applicant does not respond within the 5 business days, then the adverse action notice can be sent. So after the final decision is made not to hire the applicant, you send an adverse action notice, and it has to state the following: that the applicant was rejected because of information in the report, the name, address, and phone number of the background check company that sold the report, that the company selling the report didn't make the hiring decision, and that the applicant has a right to dispute the accuracy or completeness of the report. Okay, so I wanted to share some other considerations, moving away a bit from the compliance piece, regarding background checks. So I work with a lot of clients that when I ask the background check question, they say, oh, well, I just check Iowa courts online. And my recommendation for Iowa courts is, just because this information is available does not mean that you should use it. And so there's a few different reasons for that recommendation. As I mentioned previously, applicants have the right to appeal information found in a background check. And so generally, if employers are using Iowa courts, they're not getting a written authorization, first of all, which is an issue, but applicants aren't also getting that right to appeal under the FCRA, which is problematic. Another issue I see is that a best practice for running background checks is to only review convictions, not charges, and only within the last 7 years. And so Iowa courts does not limit the search at all. It shows you everything that's ever happened in Iowa, all the tickets, just kind of everything. And so I see that employers could be open to some potential liabilities if they take adverse action based on information available on Iowa courts online. Another tool in the public record search is the state of Iowa criminal history record search. So if applicants are receiving the required notices under the FCRA, then this could be compliant with the requirements of the Act. However, another issue I see with this one is that this only checks Iowa records. And so it is generally recommended to do a nationwide search to mitigate the risk of potential negligent hiring claims. So to ensure compliance with the FCRA and to do a nationwide search, as Kyle mentioned, we do generally recommend partnering with a background check vendor. Okay, with the FCRA and the other considerations in mind, I wanted to share a sample hiring process timeline that includes the background check, so it is compliant with the City of Waterloo Ordinance. This probably looks pretty similar to a hiring process that you have today. For some employers on the call, this may look the exact same. So step number 1 is have the employee complete the employment application. Step number 2 is take the applicant through your company's standard interviewing process. Number 3 is if the applicant is determined to be a good fit, make that conditional offer of employment. Number 4 is if the candidate accepts the conditional offer, ensure you obtain the appropriate background check consent forms from him or her. Number 5 is conduct the background check. Number 6 is when you receive the report, review that background check result. And then number 7 is make your final hiring decision. It's important to keep in mind that under the City of Waterloo Ordinance, the adverse hiring decision based solely on the results of a background check can only be made with a legitimate business reason. As Kyle mentioned, the tax accountant, tax fraud, that could be considered a legitimate business reason. So this is just a sample hiring process. You are able to take it and customize it to fit your company best. Perhaps there's group interviews or a personality assessment or something like that that could be worked into this timeline as well. Okay, we've covered a lot of different ground and a lot of compliance, so thank you for sticking with me. I wanted to share 3 takeaways that if you remember nothing else from today's session, I hope you remember these things. So the first is that conducting a background check is not required under the new City of Waterloo Ordinance that goes into effect July 1 or under existing federal law. However, if they are included as part of your hiring process, Waterloo employers must conduct them after that conditional offer of employment. The second is if you have a valid business reason, you can rescind a conditional job offer. And then the last is sample FCRA language and other resources such as a copy of today's presentation and the PowerPoint will be available on the city website. Okay, I also wanted to provide some actionable next steps based on the size of your organization. So for Waterloo employers with 4 to 14 employees, we recommend reviewing your employment application, those that are on paper and in electronic format, and removing the criminal question on the application itself. This would also include any box or any line that's associated with a criminal question. For Waterloo employers with 15 or more employees, it's that same step of reviewing the application and removing the criminal question or box or line. But it's also reviewing your hiring process, including your interview questions and your background check requirements to ensure compliance with existing federal law and the city ordinance. Lastly, I've included some considerations for all Waterloo employers, and ideally this is for all employers everywhere, but consider a legal review of your hiring process to ensure that it's non-discriminatory, and train your recruiters and hiring managers on legal hiring practices. So sometimes HR knows what's going on, but you have a frontline manager or supervisor who jumps into an interview and may not know the legal questions that he or she can ask and could get the company in hot water. So I think it's important to have anyone involved in the hiring process to be trained on legal hiring practices. Okay, another quick reminder that Kyle and I are not attorneys, so no information in today's presentation is intended to provide or suggest legal advice. And if you are seeking legal advice, you should do so from your in-house or other third-party counsel.
All right, thanks, Lauren. The only one comment I would say on the slides that Lauren covered, that is required regardless of this ordinance. That's all federal and state regulations that are currently in place. So be aware that that requirement and some of that compliance information is already currently in place. So great job, Lauren.
Thank you. And I have one more slide just to kind of talk through how to access this information after today's webinar. Thank you so much. So if you still have questions after today's webinar, you are able to go to the website. Kyle, we can see your questions, just let you know.
Oh,
thank you. Sorry. So you're able to visit the website to submit your question. It'll be answered by local HR professionals. Kyle keeps joking that it's going to be all me, but our team that helped put together the presentation will be answering those. The website will also contain sample FCRA language, other compliant hiring resources, a copy of the slides from today's presentation, and then it'll also include the recording link. So this will be on the city website and the city's YouTube channel. And then we encourage you to share this with anyone you think may be interested, anyone who couldn't make it today. We want to get the word out about the ordinance that will go into effect in 2 weeks from today. Lastly, I have the HR continuing education information for both SHRM and HRCI. So Kyle, do we have any more questions we want to share?
yeah, sorry, you could see my Q&A questions there. I was just
sorry.
So yeah, we had a couple of Q&As come in, so I'll read those, and you know, we'll answer them as we can. Some of these questions we may not be able to answer because we are not legal experts. But one of the questions was, what if a candidate is required to pass a federal background check in order to get the position? Can you ask if those conditions exist? My answer to that would be, sound like a lawyer, it depends. It depends on the organization, and I would refer this individual to take a look at the ordinance to see if their organization is exempt. There are some situations where, you know, potentially there's a bona fide occupational job requirement for somebody to have something like let's say a CDL. However, asking specific questions related to criminal convictions related to a motor vehicle record may violate this ordinance. So again, I would encourage that individual to seek a legal expert to advise on that topic. One clarification to what I spoke about, you know, the fact that if somebody shares a criminal conviction during an interview, that you should disregard it. And so this individual said, you stated if the candidate shared criminal convictions, an employer must disregard, but the ordinance states if the applicant voluntarily discloses any information regarding his or her criminal record at the interview, the employer may discuss the criminal record disclosed by the applicant. So that is correct. That verbiage came out of the ordinance. It can be discussed, but my guidance there, or my concern with utilizing that in a hiring decision is, if you bypass your standard hiring process, you are potentially running afoul of the FCRA and potentially creating an adverse impact because you have not followed the same standard process for all applicants as you did with that individual. So the recommendation is, or my intention with that statement was, you should continue to follow your normal practice, disregard that information, and then and continue with your typical process. So don't use that as the sole reason for a job turn down, was really my point there. Comment here, it would have been helpful to broaden the presentation to include nonprofits and businesses with multiple locations in the state of Iowa. So I can speak to this. The ordinance does cover employers. It does not make a distinction between for-profit or not-for-profit. There are some distinctions for some exemptions, but the content includes all employers with more than one employee. And there's a difference between the level of 2 to 14 employees versus employers with 15 or more. So be aware that does include nonprofits in some of those cases. To the comment on multiple locations, so my organization has 27 locations in 11 different countries and 9 different locations in the US. So my approach is that we've banned the box on all applications, so I don't have to worry about it. But then in Waterloo, I have specifically taken additional steps to clarify the ordinance requirements and ensure that my managers and interviewers are specifically trained on this ordinance and requirements. We don't have any conviction questions during our interview process intentionally. We have not for years, but that is my approach. So if I understand that can be a challenge from an organization and consistency perspective for a number of employers with multiple locations. I get it. Question here on questions related to applicants' driving history. Are questions related to an applicant's driving history prohibited? Again, it depends. And I would advise somebody to discuss that with an employment attorney. But from my perspective, if I were hiring DOT drivers, which I have in the past, and that's a bona fide occupational job requirement, my opinion would be you can ask them, do they have a CDL license? But if it gets into asking a question about motor vehicle record and criminal convictions, then you may be running afoul of the ordinance. But again, I think that you could still conduct the conditional job offer, conduct a motor vehicle record check, and if there are concerns that pop up in the motor vehicle record history, then that would be the appropriate time to discuss the circumstances after a conditional job offer and make the potentially make the job rescinding decision upon that discussion. Lauren, you look like you have something to say on that.
No, I was just 100% agreeing with you on that. I think I generally advocate for the least risky strategy, and that would be the least risky strategy in this case, is to ask only if they have a valid CDL. I would stay away from other questions, and then you can dig into it after that conditional offer.
Yeah, I agree. I think, and my logic there would be if you need a license to practice something, an employer needs to be able to ask that question, right? And then the question on who do we contact for further education within the community regarding the Fair Chance Initiative. So I would just say, our organization, the Cedar Valley Society for Human Resources Management, we are an available organization. Our goal is to educate people on HR practices within the Cedar Valley. So we are happy to help and support that. And then I would also just say that the City of Waterloo website has a number of resource links. There are also all of the disclosure statements that Lauren mentioned. There are some checklists, some additional resources related to the federal bonding program, and there are a number of initiatives out there and support resources for an organization. So I would point you to that website, and if there are still some questions, we're happy to help at the Cedar Valley SHRM. For anybody who is doing this for continuing education credit, I would just call out that the HR continuing education information is located here on this slide. You can use that to submit for your digital certification credits. Let me check to make sure that we don't have any more Q&A. It sounds like I was not aware that the video did not work for everybody, unfortunately, and it's a great video. So make sure you have some tissues handy, but you can access that video if you go to Iowa Job Honors is the organization that puts those videos together. Steve's story is there, but there are a number of stories that are really, really powerful that go into a number of different types of barriers, from hiring individuals with disabilities to individuals who had a criminal conviction in their background as well. So I would strongly encourage you to check that out if you have any interest, and I apologize that the video didn't work. So it was kind of like,
problem. You looked really excited. You look really excited watching it. So I think I saw
no.
that it would be,
I wasn't crying, was I?
No.
Okay.
It will be posted on this resource links site on the Fair Chance Initiative, so everyone can watch it. So hopefully you get a chance to check that out. So I think with that, we've made it through all of our Q&As. So I'm going to turn it over to Councilperson Sharon Juan. She has been instrumental in bringing this task force together and to create today's presentation. So I will turn it over to her to close out. Thanks, Sharon.
Thank you. Thanks a lot, Lauren. Yes, I'm Sharon Juan. I have the honor of serving as the Waterloo City Council at-large member and the Mayor Pro Tem. As many of you now realize after this presentation, the Waterloo's Fair Chance Initiative doesn't change many of your hiring practices. If you're currently performing background or criminal checks, the same federal guidelines will apply. But the difference that's so important to all of us is this is going to ensure that everyone has a second chance. As a reminder, today's performance and presentation will be posted on our website, along with a lot of helpful links and the ability to forward us any questions you may have. Finally, I want to thank the entire committee that I had the opportunity to work with and chair, who worked so hard on putting this together. As was mentioned, the committee included professionals from the city of Waterloo, as well as HR professionals from throughout the community. I especially want to thank our stars, Kyle and Lauren. And to all of you, thanks for participating. Please share this resource with your peers and your colleagues, and let us know how you think this went and if you need more information. And have a wonderful day. Thank you so much.